Good morning. Please be seated. We are on the record in the state of Arizona versus Ramon Bueno, CR 2014-149887-001 and CR 2014-149, just that case. Counsel, appearances, please.
Good morning, Your Honor. Ellen Dahl on behalf of the state.
Good morning, Your Honor. Vernon Lorenz appearing on behalf of Ramon Bueno.
Good morning, and good morning, Mr. Bueno.
Good morning.
May I please have your full name and date of birth, sir?
Ramon Bueno, May 13, 1975.
Thank you, sir. All right, this is the time set for a priors trial, followed by a sentencing in this matter. My understanding, Mr. Lorenz, is that your client is ready to proceed with an admission of historical prior felony convictions?
He is, Your Honor.
All right. Mr. Bueno, do you read and understand English, sir?
Yes, ma'am.
Have you had any drugs, alcohol, or medication in the last 24 hours?
Yes.
Is that medication that has been prescribed to you by a medical professional?
Yes.
Have you had any, or is it your intention to admit that you have previously been convicted of 6 prior felony convictions as set forth in the state's allegation of historical prior felony convictions filed on December 22nd, 2014?
Yes.
And does that include, on March 7, 1993, you committed the crime of attempted aggravated assault, a Class 4 felony? On March 7, 1993, you committed the crime of attempted aggravated assault, a Class 4 felony. On January 21st, 2004, you committed the crime of theft of means of transportation, a Class 3 felony. On January 21st, 2004, you committed the crime of possession of dangerous drugs, a Class 4 felony. On May 27, 2004, you committed the crime of possession of dangerous drugs, a Class 4 felony. And on October 11, 2004, you committed the crime of trafficking in stolen property in the second degree, a Class 3 felony. Are those the priors to which you are going to plead to, or that you are going to admit today?
Yes.
All right. And do you understand that admitting to prior convictions will increase the sentences on your new convictions without prior felony convictions?
Yes, ma'am.
You do understand that?
Yes.
And do you understand that if you did not have any prior felony convictions, the Class 2 felonies to which you are pleading guilty, you would be probation eligible, and you would face a range of 3 to 12.5 years with a presumptive of 5?
Yes.
And the Class 6 felonies to which you have been convicted, if you did not have any prior felony convictions, you would be facing a range of 4 months to 2 years with a presumptive of 1 year.
Yes.
Judge, there was a dangerousness finding. He is not probation eligible.
In addition, that would be if you were sentenced under the non-dangerous first felony offense. However, the jury did make a dangerousness finding if you were sentenced on the counts 2, 3, 4, 7, and 5, there were dangerousness findings. Counts 2, 3, and 4, you would be subject to a range of 7 to 21 years with a presumptive of 10.5. And on count 5, you would be facing that same range. Do you understand that, sir?
Yes, ma'am.
Thank you. The range that the state put, or the court put on the record for the Class 6 felonies would remain the same. Do you understand that by admitting the allegations of prior felony convictions, you give up certain constitutional rights, and those rights are as follows? You have the right to keep your denial of the allegations and to have a hearing before the court. You are presumed innocent of the allegations, and at the hearings, the state would have the burden of proving those allegations by clear and convincing evidence. Your trial rights do include the right to confront and cross-examine the witnesses presented by the state and the right to present evidence and to subpoena witnesses to testify in your defense. And you have the right to testify at trial if you wish. You also have the right to remain silent and to refuse to testify. Your silence could not be used against you. Do you understand these rights?
Yes.
And do you want to give up these rights and admit to your prior felony convictions?
Yes.
All right. Let's start with the first offense listed in the allegation and go through them. Starting with the first, do you admit that on March 7, 1993, you committed the crime of attempted aggravated assault, a Class 4 felony, and that you were convicted of that crime on January 7, 1994, in Maricopa County Superior Court cause number CR 1993-004174, and that you were represented by counsel in that matter?
I pleaded no contest to that.
But you understand that you were convicted
Yes.
after you pled no contest?
Yes, ma'am.
The court found you guilty. Do you
Yes,
understand?
ma'am.
Thank you. Do you also admit that on March 7, 1993, you committed the crime of attempted aggravated assault, a Class 4 felony, and that you were convicted for that crime on January 7, 1994, in Maricopa County Superior Court cause number CR 1993-004174? You admit that, sir?
Yes, ma'am.
Do you further admit that on January 21, 2004, you committed the crime of theft of means of transportation, a Class 3 felony, that you were convicted for that crime on March 21, 2005, in Maricopa County Superior Court cause number CR 022-805-001, and that you were represented by counsel in that matter?
Yes, ma'am.
Do you further admit that on January 21st, 2004, you committed the crime of possession of dangerous drugs, a Class 4 felony, and that you were convicted for that crime on March 21st, 2005, that conviction arising in Maricopa County Superior Court cause number CR 2004-022-805-001, and that you were represented by counsel in that matter?
Yes, ma'am.
Do you further admit that on May 27, 2004, you committed the crime of possession of dangerous drugs, a Class 4 felony, and that you were convicted for that crime on March 21, 2005, in Maricopa County Superior Court cause number CR 2004-015321-001, and that you were represented by counsel in that matter?
Yes, ma'am.
Finally, do you admit that on October 11, 2004, you committed the crime of trafficking in stolen property in the second degree, a Class 3 felony, and that you were convicted for that crime on November 16, 2005, in Maricopa County Superior Court cause number CR 2005-005-550-004, and that you were represented by counsel in that matter?
Yes, ma'am.
Are you making these admissions because of any promises or agreements of any kind that I have not placed on the record today?
No, ma'am.
Were there any threats were any threats made or was any force used to get you to make these admissions?
No, ma'am.
Counsel, anything before I proceed?
No, Your Honor, thank you. I will supplement the record. I do plan on marking the latent print examiner's report, which was disclosed to counsel, along with the priors pack, which would support exactly that admission here.
All right, and those have been marked?
One has been marked and the second is being marked, just for the record.
All right.
Nothing from us.
Mr. Lorenz, do you stipulate to the admission of these two documents?
I do.
Okay, the court will accept and admit exhibits 1 and 2. The court does find that the defendant's admission is knowingly, intelligently, and voluntarily made. There is a factual basis for it. The admissions to the 6 prior felony convictions that the court has gone over with defendant are accepted and entered. Now let's proceed with sentencing. At a jury trial, the jury did find the defendant guilty of the following: 2, aggravated assault, a Class 2 felony committed on or about October 8th, 2014, and the jury did make a finding that this was a dangerous offense. The jury further found the defendant, and the court finds the defendant guilty of count 3, aggravated assault, a class 2 felony committed in violation of Arizona law on October 8th, 2014. The jury further found, and the court finds, that this is a dangerous offense. The jury further found, and the court finds the defendant guilty, or excuse me, it is the judgment of the court, the defendant is guilty of count 4, aggravated assault, a class 2 felony committed in violation of Arizona law on October 8th, 2014. The jury found, and the court further finds, that this was also a dangerous offense. It is further the judgment of the court, based on the jury's finding, the defendant is guilty of count 5, drive-by shooting, a class 2 felony that was committed on October 8th, 2014. The jury found, and the court further finds, that this is a dangerous offense. It is also the judgment of the court that the defendant is guilty of count 7, threatening or intimidating, a class 6 felony committed in violation of Arizona law on October 8th, 2014. It is further the judgment of the court the defendant is guilty of count 8, threatening or intimidating, a class 6 felony committed in violation of Arizona law on October 8th, 2014. It is further the judgment of the court that the defendant is guilty of count 9, threatening or intimidating, a class 6 felony committed in violation of Arizona law on October 8th, 2014. Turning to counts 11 and 12, a jury previously found the defendant guilty of these 2 counts. On January 16, 2019, based on the jury verdicts, it is the judgment of the court that the defendant is guilty of count 11, possession or use of dangerous drugs, a class 4 felony committed in violation of Arizona law on December 3rd, 2013. It is further the judgment of the court the defendant is guilty of count 11, count 12, possession of drug paraphernalia committed in violation of Arizona law on December 3rd, 2013. In preparing for today's sentence, the court also takes into account that the jury did find the defendant guilty of the following aggravating circumstances: that this offense involved the infliction or threatened infliction of serious physical injury, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun, that the offense caused physical, emotional, or financial harm to the victim, and that the offense was committed with the intent to promote or further assist any criminal conduct by a criminal street gang, with respect to counts 2, 3, 4, 5, 7, 8, and 9. Finally, as previously stated on the record, the jury did find that counts 2, 3, 4, and 5 were dangerous offenses. The court would note that there has been no jury finding as to aggravating factors on counts 11 and 12. However, the court would note that the defendant's prior felony convictions would serve as an aggravating factor as to counts 2, 3, 4, 5, 7, 8, 9, 11, and 12. The court did preside over the trial in both of these trials, the trial that concluded on January 16, 2019, as well as the trial that concluded on December 19, 2019. I have considered all of the information that was presented during that trial. I also did receive a written sentencing memorandum from the defense. I did not receive anything else in writing from the state, correct?
Correct.
All right. So with that being said, would the state like to be heard concerning sentencing?
Yes, Judge, there are a few individuals from our community who would like to address the court, starting with the original case agent, Jan Butcher.
Thank you. Please just state your name for the record and then provide me with your statement.
Yes, ma'am. Jeanette Butcher,
And can you spell that for me, please?
Jeanette, Butcher, Butcher.
Thank you. Please proceed.
Good morning, Your Honor. I was the case agent for this investigation, and I know a lot of people will be speaking today, so I'm going to be brief. I would just like to mention a few things about this investigation. The defendant has denied any involvement and continues to fail to accept responsibility for his actions. On the early morning hours of October 8, 2014, the defendant had no regard for the life or respect for law enforcement. The actions by the defendant and his blatant disregard for human life could have easily killed Trooper James Casey, Ronaldo Cruz, and Mike Alfano. Because the defendant's actions, the lives of these officers, their families and friends have been changed forever. The initial response to the crime scene had personnel from the Arizona Department of Public Safety, Phoenix Police Department, United States Marshal's Office, ATF, the U.S. Secret Service, Maricopa County Attorney's Office, and the FBI. A task force was established to apprehend the suspect. Employees were pulled together from other units within the Phoenix Police Department, and they were assigned to work 12-hour shifts to assist homicide investigators without any days off. The investigation was exhausting on all investigators involved, and personally, I was without sleep for several days worrying about the defendant as to whether he was going to kill, injure, or seriously disable anybody while on the run in his effort to elude police. The defendant was a known violent gang member and would not hesitate to hurt or kill others in furtherance of his criminal street gang. When the defendant was interviewed after he was arrested, he denied any and all involvement, although physical evidence and witness statements put him inside the vehicle and as the shooter. During the interview, it was more important for the defendant to stay in good graces with his gang rather than be a man and accept responsibility for his actions. I respectfully ask that you sentence the defendant to the maximum on each of the counts. Thank you very much.
Thank you.
Your Honor, Clint Davis.
Thank you. Mr. Davis, if you could please come forward. Counsel, Mr. Davis, stay there, please. Go back.
I'll actually take one moment if you don't mind.
Thank you. Thank you. I apologize, Mr. Davis. You could please come forward. Your full name and then your state.
C-L-I-N-T, Davis, D-A-V-I-S.
Thank you, sir. Please proceed.
Good morning, Your Honor. I'd like to just sort of address the court on the matters of the Arizona Mexican Mafia. I've worked criminal street gangs for over 30 years. I've worked the Arizona Mexican Mafia for over 2 decades. And in that time, I've found that not only are they one of the biggest threats on the street, but also within corrections as well and detention facilities. I think that everybody needs to know that based on their own code of conduct, it mandates that they commit violence, that they spill blood. It mandates that they support other members. And I think it's really important to show that Mr. Bueno, he will never be safe in society to other people. Other people around him will always be in danger. The actions of Mr. Bueno, those are brownie points for him, Your Honor. Not only will he have elevated status and reputation within the Arizona Mexican Mafia, but within the ranks of inmates overall because of his actions of seriously injuring a law enforcement member and nearly killing him. And the other thing, Your Honor, is we have statutes for a reason dealing with criminal street gang members. They are one of the biggest threats to society there are. They are responsible for a very large proportion of crime committed on the streets, yet their ranks, they're very low population of the actual criminal activity in society. It's so disproportionate that when they get into the Arizona Department of Corrections, they just keep right on committing crime, whether that be money laundering, conspiracy to commit additional violence, promotion of prison contraband. It's just ongoing, Your Honor. They have no, I have my opinion, Mr. Bueno will always be a threat to society. He has shown himself to be a career criminal. And unfortunately, Arizona Department of Corrections needs to really watch him when he gets back into custody, because reviewing his security threat group file, he should have never been out of custody in the first place, because it clearly showed that he was involved and engaged in criminal activity on his previous occasion in the Arizona Department of Corrections. From what I can see, it was not investigated. No actions were taken. So, Your Honor, I would say respectfully that any member, Mr. Bueno included, of the Arizona Mexican Mafia and criminal support structure as well, they are a threat to society. And so in that case, my opinion would be that they really belong incarcerated. He's proven that repeatedly, and he's shown no remorse. He hasn't taken responsibility, Your Honor. Thank you very much.
Thank you.
Your Honor, I'd like to take some time to talk to the court about Mr. Bueno, and then finally, James Casey would like to address the court.
Of course.
As you stand here today, you have to make a determination not only about what happened on these two different days, but more importantly, the time in October of 2014 and when he was caught with drugs again in December of 2013. And in looking at that, you have to know, who is Ramon Bueno? He's a 44-year-old man who stands before this court, as Detective Davis said, a career criminal. He poses a threat to public safety, our community, public service officers. He is a proud member of the Arizona Mexican Mafia in good standing to this day. He has zero regard for human life. You saw from this pre-sentence report that you received by the probation officer involved that his criminal history started at the troubling age of 10 years old. He has been given every opportunity in our community, and I'll talk about that in a minute. And so as you determine what is fair, what is just in this case, it's important to have information regarding who he was even before October of 2014. And I'd like to quote, so as to not misrepresent, the prior pre-sentence reports. In 1988, for a burglary in the second-degree referral, he was placed on juvenile probation. He violated and then continued on juvenile probation in 1989. In 1990, he was committed to what is basically juvenile prison for a weapons violation. In 1991, he was committed twice to the Department of Juvenile Corrections for sale of narcotic drugs and a weapons violation, a gun. In 1992, he was again committed to the Department of Juvenile Corrections for possession of drug paraphernalia. The defendant was suspended from high school on numerous occasions for truancy, arguing with teachers, and fighting with peers. He reported that he dropped out of Central High School during the 11th grade because he was fighting in school with other gang members. He then transferred to Carl Hayden High School and got into fights at that school as well. When he quit high school, he finally got a job for a minute. That's not a quote, that's me. I really want to talk to you about where he started at the age of 18. And I'll say this, it's the 2 aggravated assault counts that he pled no contest to, that he agreed that he had today. He had to agree to it. He went to prison for 16 years. And quite frankly, in my estimation, that 16 years was far too short, and we were not well served by that disposition. Let me tell you about what he did then. On March 7th of 1993, and this is from the court's probation pretrial services, at approximately 3:40 a.m., Phoenix police responded to a shots fired call at 3100 West Madison Street in Phoenix. Members of the Southside 35th Avenue gang had been milling in the street where there was a party. They were encountered by the defendant, Ramon Bueno, and some of his friends, who, as you know, are all members of the Cofelt Jets criminal street gang. A fist fight ensued between the rival gangs, in which the defendant was struck in the back of the head by George Lerma. Several people there stated the defendant then took out a gun, approached George Lerma and Raul Tellez, who were standing on the sidewalk next to a white Ford Fiesta. The defendant shot Raul Tellez, then walked around the rear of the car and shot George Lerma, who was crouching down beside the car in an attempt to avoid getting hit. Neither of these 2 victims were harmed. I will tell you that Raul Tellez was shot in the back of the head by the defendant. George Lerma was shot in the back, the chest, the arm, and the stomach by the defendant. Both of those individuals are to this day permanently paralyzed and confined to wheelchairs because of the defendant. And those victims back then, before the court, indicated George Lerma, the court stated that the defendant, Ramon Bueno, should have been charged with attempted murder. He said he's not looking for revenge, he simply wants justice to be done. He said that the defendant shot Raul Tellez first, then him, and then he came around the car to finish Raul off. Mr. Lerma stated he was shot 4 times by the defendant and he's paralyzed for life. And at the time, he was living with his family. Now, Raul Tellez, the other victim in that case, his left side was paralyzed. He was confined to a wheelchair. He was unable to talk at the time of the pre-sentence report because of the defendant. And doctors at that time did not think he would ever regain his speech because of those actions of the defendant. The mother of him had to quit her job to care for her son full time. He was in a nursing home, and that mother said that the defendant, Ramon Bueno, is a killer and that her family is living a nightmare every single day. The defendant served his time in prison. You heard from Detective Clint Davis. The defendant was one of the individuals in the Department of Corrections, Your Honor, who is especially dangerous when in prison. He was what we call validated. It's a civil process where they find the people who are most involved in the criminal street gang lifestyle. And those individuals, out of approximately 40,000 inmates in the Arizona Department of Corrections, they target those who they believe are the greatest threat. And there's an opportunity for the inmates to challenge the process. The defendant was validated as a member of the Arizona Mexican Mafia. And there's less than 500 individuals who are validated, to give you a sense of scale in terms of threat. Detective Davis, in preparing for this trial and in looking at a related investigation, looked at the STG packet. I agree with Detective Davis. There were hit lists that were associated with the defendant. There were promoting prison contraband. There were multiple crimes that he was committing while in prison, in our estimation, albeit uncharged. But the ongoing criminal street gang lifestyle, he went to prison and he loved it. And he graduated, as you heard during trial, from the Cofelt Jets to the Arizona Mexican Mafia. And that's what he was about back in October of 2014. when his life intersected with the 3 troopers' lives. And in the interim, while he failed on parole, he failed on probation, he was given multiple more chances after he came out of prison. You see from his criminal history, he victimized people, he was trafficking in stolen property, he was stealing cars, he was doing drugs, he was even shoplifting while having methamphetamine. Those were all in his prior pre-sentence reports. And I have those here if the court would like to review them.
I have them, thank you.
Thank you, Judge. Now, as you determine what is fair and just, you heard at trial. I will tell you this. We are asking, as we spoke about previously, that you run the victim counts in this case consecutive to each other. And I would like to provide the case law to support this request. State v. Gunter, 132 Arizona 64, tells us that the Arizona courts view it this way. Where crimes against persons are involved, we believe a separate interest of society has been invaded with each victim, and that therefore where 2 persons are assaulted, there are 2 separate offenses. A court does not violate the double jeopardy clause where a single act harms multiple victims, and there are numerous cases that would illustrate that principle. But simply stating with State v. Gunter, that was where the court affirmed the imposition of 2 consecutive terms of imprisonment for the single act of throwing acid because that single act had injured 2 victims. In this case, as you know, from what was brought out at trial and that the jury found the defendant guilty of, he shot at the 3 troopers, Ronaldo Cruz, Mike Alfano, James Casey, particularly when James Casey was laying there dying on the ground and but for medical attention would have died there. As we talked about, the aggravating factors in this case to support my recommendation will be the prior poor performance on probation, the failure on parole, the nature of the priors, the especially heinous, cruel, and depraved manner in which the offense was committed, the fact that you had 2 troopers who were rendering aid to a man who had been shot in the face and were in a vulnerable position as the car came back around and he chose to shoot once again at these 3 men, the threatened infliction of serious physical injury, the prior nature of his criminal history of the aggravated assaults, his flight, his avoiding arrest, and then I want to talk to you about the crime. As you know, as an experienced Superior Court judge, aggravated assault, a Class 2 dangerous felony against a law enforcement officer, encompasses a lot of conduct. It could be standing on a street corner, raising a shirt while there is a weapon in the waistband, placing them in reasonable apprehension of imminent physical injury. That is the same crime. And so when looking at what is appropriate in this case, at the range that is before this court, the defendant was actually shooting at these 3 men on the night of October 8th, 2014. It wasn't a pointing, it wasn't a threat while holding it, it was shots fired. And I think that is important when reviewing what is appropriate and just in this case. The defendant is a member of the Arizona Mexican Mafia. And finally, I will say this, Judge, the harm to the victims. It was particularly hard as I stand you here as an officer of the court to hear Ronaldo Cruz during the trial testimony talk about what he experienced that night, talk about what has happened to him since then. The defendant ended 3 career law enforcement officers' careers. Mike Alfano, he no longer works as a law enforcement officer. Ronaldo Cruz no longer works as a law enforcement officer. James Casey no longer works in his profession that he always wanted. And you heard from him and you'll hear from him today. I will tell you it was difficult to sit here and hear the devastation that this man has caused to other people. His criminal behavior is completely outside the boundaries of a civilized society, and it shocks the conscience. And he is someone who, quite frankly, as everyone has said, has a complete disregard for human life. How many people has he harmed? How many chances have people given them? He does not deserve the hope of light at the end of the tunnel. He should know that his sentence should keep him in prison for the remainder of his life. He has sentenced so many other people to day-to-day reminders of his actions, of how he was in control. He sentenced other men to a lifetime of living in a wheelchair, one who cannot speak, and then what he did in October of 2014. I'm asking that you impose the maximum term of 35 years on count 2, the count related to James Casey, with the additional 5 years to be added on because of the gang sentencing enhancement found by the jury, to run consecutive to count 3, the maximum term, with an additional 5 years because of the gang sentencing enhancement found by the jury, to be run consecutive to count 4, the count involving Mike Alfano, and the 5 years.
You're asking me for 40 years on each?
Yes.
Thank you.
I'm asking that the drive-by shooting count, an aggravated term be imposed, and that it run concurrent to count 4, that an aggravated term be imposed for count 7, 8, and 9, and each count to run concurrent with the aggravated assault count for that same victim. So count 7 to run concurrent with count 2, count 8 to run concurrent with count 3, and count 9 to run concurrent with count 4.
And so that we are clear, on counts 7, 8, and 9, you are asking for the 3-year enhancement?
Yes, Judge.
Thank you.
And finally, as it relates to count 11 and 12, I'm asking that count 12, the presumptive term be imposed and run consecutive count 11. Count 11 was a trial in January of 2019 where he was found with methamphetamine. At that point, that was his 7th prior felony conviction.
You want me to run counts 11 and 12 consecutive to each other?
No, concurrent to each other.
Okay.
I think case law demands it.
I do too. I just wanted to make sure.
And count, 11 to run consecutive to count 4. And I ask for that, Judge. There is no temporal, any aspect of that matter 9 months before or 11 months before what he did in October of 2014 that would call for a concurrent sentence. It was a completely different crime and it has nothing to do with what he chose to do, and no leniency should be shown to this man whatsoever. At this time, I would ask permission to allow James Casey to address the court.
Good morning, Mr. Casey.
Morning, Your Honor. My name is James Casey, Jamescasey.
Thank you, sir.
First of all, I'd like to thank the court for allowing me to speak. I'd like to also thank the Phoenix Police Department and Detective Butcher for the excellent work that they did, and all the other agencies that were involved. I don't really have much to say. I said most of it when I was testifying. The couple of things that I will mention is, one, originally I was going to ask you to sentence him to, I know numerically it's not possible, to 155 years in prison, 1 for each stitch that I received in my mouth, but obviously that's not there. I would ask you, though, I'm in concurrent with Attorney Dahl. I would like you, if possible, to run all these sentences consecutive as long as possible, so he will never see the light of day. He is a very dangerous man. Had he just kept still that night, we wouldn't be here. I would have dealt with the driver. I would have probably given her a warning for the window tint violation, and away they would have been. His actions what caused us being here today. I will say, in respect to the court and time, if he is sentenced to enough time that it assures myself, my family, Ray Cruz's family, Ray, Mike Alfano, and Mike's family, that he will never see the light of day. I will ask the county attorney, I will not be interested to go forth with the attempted murder trial. I just don't think there's a need to put salt on the, add more insult to injury, I guess, so to speak. So I appreciate it, and thank you.
Thank you, sir. Oh, you are done?
Yes, Judge, do you have any questions for me?
I do not. Thank you.
Thank you, Your Honor.
Mr. Lorenz?
Thank you, Your Honor. Thank you, Your Honor. You know, this was a tough one. Excuse me, it's a tough one. It was starting in January when we tried those first 2 counts in front of you. But you are in the unique position to decide what the sentence should be. And you're perfectly situated for that because you heard both trials, you've seen the pre-sentence report, you've heard the arguments of the state. All I ask is that you fashion a sentence that's just, that you take into account the things I put in my sentencing memorandum. Should also point out that Mr. Bueno's got his sister Ida in the gallery to your left and some other loved ones, family and friends. Ida's chief among them. She was here as often as she could during the trial, as often as she could be here. So that's what we ask, just a fair and just sentence. Mr. Bueno respects the work of the jury, but he respectfully disagrees with their verdicts. And so that's all I have. I think Mr. Bueno would like to address you. Thank you.
Of course. Mr. Bueno?
I would just like to say that I am sorry for what happened to James Casey. And regardless of what they continue to say about me, that he always been in my prayers. But I also like to ask James Casey, as well as Ellen Dahl, if they can look up in the Lord's book and look up Exodus chapter 20, verse 16. That's it. Thank you.
Thank you. You'll give me a moment, please. And I apologize for the time that this takes. The court's computer system requires that I open each count separately, and I have to go in and clear the memory because I don't have enough memory on my computer to do all the counts in this case. So it does take me some time, and I apologize.
Thank you.
Does your client waive his presence if there is a restitution hearing?
He does, Your Honor. Thank you.
This time, my understanding is we do not have a calculation of an amount for restitution. Is that correct?
Yes, Judge.
Is there a period of time that you are asking me to hold restitution open?
Judge, I would ask 1 year.
Thank you. All right, amending the previous record, I did not place on the record the fact that I had reviewed the pre-sentence report that was prepared and filed in this case. I have reviewed that pre-sentence report. I would also note that for purposes of the sentencing, I did review and consider the pre-sentence reports referenced by Ms. Dahl. However, my sentence is based on the information contained in the pre-sentence report in this case and the information that I heard in trial at this case. That has been the focus of my attention in the sentencing in this matter. Before I begin, I would like to say that I understand my role here today is to mete out justice, and I will do so. I will be imposing a sentence that I believe is fair and appropriate, but in no way will this sentence compensate the victims for the harm that was caused to them. I want to thank officers, and I apologize if I get officer versus trooper. The name changed in the middle, so I want to thank James Casey, Reynaldo Cruz, and Mike Alfonso for their service to our community. I understand that the actions in this case prematurely ended 3 very successful careers, and there is nothing that I can do to compensate you for the end of those careers. The important thing to also remember is there's nothing that I can do to compensate you for the terror that you were feeling at the time that these actions were occurring. There's nothing that I can do to compensate the families involved who were wondering what was going on with their loved ones. There's nothing I can do to compensate the children who were wondering whether or not James Casey was going to survive. There's nothing I can do to compensate the wife of James Casey for the horror that she had to experience in thinking, is my husband going to survive? And what are my children going to do without a father?
if he doesn't. There's nothing I can do, and frankly, there's nothing anyone can do to compensate you for those experiences, other than for me to say, thank you for your service. Thank you for what you have done. And we are deeply indebted to you for the risks that you and other people like you take every day in protecting our community. So thank you for that.
I would also acknowledge that there's nothing I can do for the family of Mr. Bueno to take away your pain. I know that it must be horrifying to sit there and think that your loved one is going to prison for the rest of his life. There's nothing I can do to change that for you other than to say, I am sorry for the experience that you are having. And I am sorry for the pain that your loved one is causing you in this moment. I wish there is something I could do to take away your pain, but I must hold him accountable. And in holding him accountable, I don't want to overlook the pain and suffering that you are also going through. Having said that, I have considered the aggravating factors that were previously placed on the record by the jury, and I've considered the information that Mr. Lorenz did provide to the court in advance of today's sentencing. Mr. Bueno, you haven't had an easy life. You've made some choices that have resulted in you being here today. I can't even fathom what resulted in those choices. I don't know who you were before you got here before me. We've been in trial together for 3 years, not trial. We've been the judge and defendant for 3 years, and you have been nothing but respectful to me. But my concern is, so what that says to me is that you have the capacity and that you have made choices that have resulted in grave harm to many, many people. But what I'm sentencing you for today is the harm that you caused to the people in this case, keeping in mind the history that brought us here. This is not an action that occurred in a vacuum. This is an action that occurred after a lifetime of other crimes. And those crimes suggest to me that you are a danger to society in addition to these crimes. So I am going to do what I feel is fair. I do find that the aggravating circumstances with respects to counts 2, 3, 4, 5, 7, 8, and 9 outweigh any mitigating circumstances, those including Mr. Bueno's upbringing, family circumstances, and the life circumstances that resulted in him being here today. Based on weighing the aggravators and mitigators, an aggravated sentence is appropriate, and I will place on the record the number of years for counts 2, 3, 4, 5, 7, 8, and 9. I will be imposing the presumptive sentence on counts 11 and 12. Starting with count 2, the court does believe that it is appropriate to give the maximum sentence allowed for the harm that was caused to James Casey. And in addition, I must add the 5 years for the gang enhancement. Therefore, the 35 plus 5 years results for count 2 in a greater than aggravated term of 40 years to begin on today's date with pre-sentence credit for 1,932 days time served. As to count 3 and 4, the court does find that an aggravated term of 28 years is appropriate, with the enhancement of 5 years for a total of 33 years on counts 3 and 4. The court is going to run the sentences in counts 3 and 4 consecutive to count 2. Therefore, the defendant will be getting 0 days credit for time served
on counts 3 and 4. Count 5, I do find that an aggravated term of 28 years is appropriate, with a 5-year enhancement for a total of 33 years. I will be running count 5 concurrent with count 2. Therefore, the defendant's sentence will begin on today's date with pre-sentence credit for 1,932 days time served. As to counts 7, 8, and 9, the court does find that the aggravated sentence for these counts is appropriate. That would be 5 3/4 years with a 3-year enhancement as required by statute. The court will be imposing a greater than aggravated term of 8 3/4 years on each of these counts. With respect to count 7, as requested by the state, I will run that concurrent with count 2. Therefore, the sentence on that count will begin on today's date with pre-sentence credit for 1,932 days time served. As to counts 8 and 9, I will run those concurrent with counts 3 and 4. Therefore, those will begin upon completion of the sentences in counts 2, 5, and 7, and the defendant will receive 0 days for credit time served. 0 days credit for time served, excuse me. Finally, turning to counts 11 and 12, the court does find that it is appropriate to impose the presumptive term on both of these counts. That includes on count 11, a presumptive term of 10 years with pre-sentence credit for 0 days time served. And on count 12, a presumptive term of 3 3/4 years with pre-sentence credit for 0 days time served. The court is ordering that counts 11 and 12 will run consecutive to counts 3, 8, 4, and 9. So that the record is clear, the imprisonment on counts 2, 7, and 5 are to run concurrent with each other, followed by counts 3, 4, 8, and 9, which are to run concurrent with one another, followed by counts 11 and 12, which are to run concurrent with one another. As to counts 2, 3, 4, 7, 8, 9, and 5, the court is ordering that the defendant shall have no contact with the victims, and the defendant shall pay restitution for all economic loss to all victims. The court is retaining jurisdiction over restitution on counts 2, 3, 4, 5, 7, 8, and 9. No hearing is set at this time. In the event a restitution hearing is set, the defendant does waive his presence. Restitution is to remain open for a period of 1 year. The court is imposing community supervision on counts 2, 3, 4, 5, 7, 8, 9, 11, and 12, pursuant to ARS 13603I. Counsel, can I ask you to please approach? Are there any other issues that the parties would like to address before I turn to the defendant's appeal rights?
Yes, Your Honor. Mr. Bueno is hopeful that he can get his wallet and his contents returned and his computer. He would like his sister Ida to be able to retrieve those when they're made available. We learned this morning that there could be some delay with the computer, but not the wallet. And again, Mr. Bueno was happy that the request was made on the record. Thank you.
Thank you. Ms. Dahl, anything you would like to address?
Judge, if we could address it on the next status conference, I can confer with my case agent regarding that and also the badge of James Casey.
Thank you. All right. The court is going to, well, first I will start with you, Mr. Bueno. You do have the right to appeal from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed for you. If you cannot afford a certified copy of the necessary records and transcripts, they will also be provided at no cost to you. You must file any notice of appeal within 20 days from today, or you lose the right to seek that appeal. You must sign for a copy of your appeal rights. The court would note that we have not yet addressed counts 1, 6, and 10. I am going to set a status conference. Dana, do I have time on Tuesday? Before 10:30? Counsel? I have a 10:30, so what can we do on Tuesday?
Judge, I'm in trial.
So maybe 9:30?
9:30 works?
Thank you.
Mr. Navarro?
Yes, perfect, thank you.
Court will set a status conference on Tuesday, February 4th at 9:30 a.m. At that time, we will discuss what we are going to do with counts 1, 6, and 10, as well as the return of Mr. Bueno's property. Is there anything else that the parties feel that we need to address and place on the record that I have not yet addressed?
No, Your Honor, thank you.
Your Honor, Mr. Bueno is eager to begin the next phase of this and head to DOC. He would prefer not to be here on Tuesday. I can certainly manage the hearing without him, and my hope is that he won't be needed in the not too distant future.
Ms. Dahl, your position?
Judge, I think it's de minimis, and looking at the big picture, this is a 6-year-old case. We still have those outstanding charges, and instead of moving him back and forth from Alhambra, because that's as far as he would get, during going through the classification process, he should only do it one time. And quite frankly, Judge, it's already Wednesday. He would probably not even be transported until after our hearing date anyway.
Thank you. Given the overall concerns and what could happen at that hearing, the decisions that could be made, the court is going to require Mr. Bueno be present. It is entirely possible that we are picking trial dates and moving forward. So without Mr. Bueno, I'm not comfortable doing that.
Thank you.
So I will be requiring his presence at that hearing. And finally, I want to close by thanking the lawyers for a very professional presentation. It has been an honor and a pleasure to have worked with all of you. Thank you very much for your service in this case. We are adjourned.
Thank you, Judge.
Okay, tell me when I'm ready. Dana, so you're holding off, right?